Okay. Well, welcome, welcome, welcome. Let me get my slideshow. There we are. We are your co-hosts today. We have myself, Chris Jones from Spectre Diversity, and our company has an assessment that measures the individual and the organization at the same time. We also in addition to the quantitative data, we have qualitative data. So we have open-ended responses, and you're going to see a few of them today. Anonymous, of course. And my co-host, one of them is Nancy. Nancy, you want to introduce yourself?
Yes, apologize for my locale. I'm on the road today, but I'm Nancy Schick of Third Ear Conflict Resolution. I am a New York employment attorney and global workplace mediator. My job is to keep employment disputes out of court.
Thank you. And we have a guest today. We have Sharon Harrington. Welcome. And she specializes in helping clients to create and enhance engaging work environments through systems that incorporate conflict as creative tension. I love that. And eliminate conflict that is disruptive and destructive. Disruptive and destructive. That's so hard to say right together. Her key focus areas include team self-assessment, visionary development, and the organizational fusion of integrated conflict management systems. This method is all part of organizational growth and development for maintaining accountability in reaching business goals and objectives. She particularly works with clients to address disputes. So Sharon and Nancy have that in common, disputes. Although the first time we met, she was very careful to say that she is not an attorney. So we have one attorney and two experts. Oh, you can't say experts. Well, two qualified people. So let's get going. So DEI for real, reassure, educate, activate, and lead. So this is part of the reassurance part. And yes, this did happen. Reassure you. Ames versus Ohio Department of Youth Services. This was last June. The U.S. Supreme Court unanimously ruled that all employees, including those in the majority group, must meet the same evidentiary standards for Title VII discrimination claims. So this decision rejected the background circumstances rule, which previously forced white or male employees to meet a higher burden of proof to demonstrate reverse discrimination. So, Nancy, well, go ahead, Nancy.
So, I taught a course on this last year, so this is a particular topic that's near and dear to my heart. Yes, the first thing is check your biases. And the big thing that we saw with this is that it came out in the decision as well. We're talking about perception of people being in the majority class. That's the big issue that came out in Ames, is because it's all about perception. Your perception of how somebody looks, what they how they might lean as far as sexual preference, gender identity, any of that. You know so little about somebody by looking at them, is basically what Ames is getting at, is that you need to do your homework. Don't just assume that because a case came to you and you're reading a certain name, for example, that you know what that case is about. You still have to do a fair and impartial investigation.
Okay, and um, yeah, Sharon, can you take this one?
One of the things that I spend a lot of time talking about when it comes to um, bias, particularly, I know you talked a lot about the assessments and some of the things, but I also, a big part of what I do is train people how to investigate charges of discrimination. And, you know, the biases are one of the things that I am very big on, because we all have them. We all have those biases, and we all bring those things to us in the sense of when we do anything, and we can't deny that. So I think that when we look at that, checking your bias, and you're given, priority to claims by employees on the basis of their identity. And always, one of the things I always say is always remember that the complaint's not about you, it's about the person in front of you. When you look at those audits.
And it's about the facts, right? That's the other thing, is that you don't know when you get the complaint what the facts are. That's why you do an investigation. But I see it over and over that people will get the complaint and they'll assume they know what the outcome should be before they even start the investigation. And that's just asking for problems.
And fear is a big part of it.
Yeah.
Nancy, what do you, or Sharon?
So that was one of my questions that I encourage people to ask themselves is, I get clients all the time that will call before they need to terminate someone. And what they'll often tell me before they tell me how many absences that employee had, or what their performance was and why it was substandard, they'll say, we're afraid to do anything about this particular situation because this person is blank, right? Just fill in the blank with a protected class. And that is what a lot of employers had done. And that's, again, how we ended up with a case like Ames, where the Supreme Court had to say, no, no, that's not how we do it. It's either discrimination or it's not. Do your investigation. So Sharon, you may have something to add to that.
With that, that kind of brings up when we talk about the so-called reverse discrimination. That's the whole point. We all know that there was never such a thing, and they talked about that. But most definitely, when you're doing that investigation, the same things apply to everybody. And I'm not sure why there's that assumption out there that it doesn't apply to white males or what. And I can tell you, I've heard some things that's just mind blowing in terms of what people say. And uh, if this ever gets in front of a judge, where that's going to go. So sticking with the facts, applying it to everyone. And the same thing as we go into DEI, when you look at those facts and you apply it the same way, how it turns out will be, very similar in the protections of everyone.
So there's a few, and I'll just go over this, and then Nancy and Sharon can respond to it. But this are the key, points of the decision. One is that it eliminated those heightened standards. So the court, and Justice Jackson wrote it, clarified that Title VII protects all individuals equally, regardless of race or sex or any of the other protected classes. It rejected background circumstances. So lower courts can no longer require majority group plaintiffs to show background circumstances indicating that the employer is the unusual employer who discriminates against the majority. Equal standing. All plaintiffs now face the same standard when bringing claims of intentional discrimination. Impact on employers. HR and legal teams should review their DEI initiatives, hiring, and promotion policies to ensure that they're neutral and they don't trigger those quote unquote reverse discrimination claims. And this ruling makes it clear. Whoops, I went too far. This ruling makes it clear that it makes it easier for majority group employees to bring discrimination claims. And it's expected to increase litigation risks for employers regarding this quote unquote reverse discrimination. Risk mitigation. Are we going to talk more about that, or do you want to do this now, Nancy? Or
I think it's going to come up throughout, because that's going to come up with some of the things that I'm sure Sharon will have some feedback on, is that there's going to be a lot more confusion is what we're anticipating, which is also why there will be a greater impact on employers. We already know that they've been getting this wrong. I know for personally, some of the cases I've worked on, it's been clear that there was a perception of some sort of hierarchy of protected classes, and that's not the way the law is written, and that's not the way the law is applied. So I did a course on that as well a couple of years ago before Ames even came out. So that's because I kept seeing these repeated errors. And what the other thing that we're anticipating on the legal end is more confusion because of the DEI bans, the executive orders, and now without the EEOC guidelines, there's a lot of employers guessing. Now, fortunately, a good portion of my clients are in New York because that's where I'm licensed to practice law. And so they still are following the state law and then some of the city laws as well, and then the rules and regulations that go with that. So they have a lot of guidance. But if you're in some of these other states where you don't have strong state laws to supplement, it can get very, very confusing. So that's why I tried to give those couple of questions that are your starting questions for could I have policies and practices that lead to litigation.
Okay.
Sharon, you
Let's
have
get,
anything to add?
I absolutely agree with that. And but when you use the term confusion, when you mention that word, that's a big part of what we're going to be seeing. And it's really interesting. Even the EEOC, they talks about there's no such thing as reverse discrimination. However, on their site, when they talk about e-race, there's a whole series of racial type complaints and what decisions they've made. They actually do have a category that says reverse discrimination. And I actually talked to one of the EEO professionals because they've always said that. And he says, well, we have it there because that's what people call it, even though it's not. I mean, they'll tell you themselves. And so I think the confusion is a big part of it. There's actually EEOC has made it a point to say we are looking at DEI discrimination. I'm seeing it in a lot of different places. And there's actually a pamphlet, a PDF that says if you've been discriminated, because of DEI, these are the step-by-step that you do. But again, the step-by-step that you do are the things that anyone would do. It's
Exactly.
not just if you are a white male. And then there was also a short video that was put out that said, if you are a white male, you can make money. It was a short video out of the EEOC from the board chair. So, the commissioner chair, shall I say, but it's one of those things where I think there's going to be quite a bit of confusion because some people are thinking, oh, now I can. And it makes it easier now for me to do it. But it always has. In fact, I have an attorney friend who one of her biggest settlements was with a white male who came to her. And she took his case, because someone had said, well, this applies to you. And he went to her. She said, she took it. And it was one of her biggest settlements in her practice. So it's always been there. And I think for people to think that, oh, now I can do it, that's where I think a lot of confusion is going to be because they think it's something different.
Right. And it's not that different. That's what we keep trying to reinforce for you.
well, and that brings us to this, what it means for DEI. Have regulations changed? Have they remained the same, or are there some eliminated? Nancy?
So not much has changed. At the federal level, what has changed and what we keep saying is that the executive orders, for example, did ban DEI programs that are considered illegal or divisive. That has not really been clearly defined yet. We have some idea what that means, but it's going to probably take some cases to define that more succinctly. And we're going to always see cases that will challenge it to either narrow it or expand it. That's the way that the law generally works. But what most people need to focus on is that the law hasn't changed. How you train your employees not to violate the law is what has changed. So most DEI had to do with programs and initiatives and quotas. And we know that, for example, the quotas are not a good idea anymore, right? You're going to draw scrutiny and possibly land in court over that. So what you need to be thinking about is going back to those key questions we mentioned earlier, is are you giving priority to claims by certain types of people? And are you, just because of your own biases, looking at some cases as not as serious based on who filed them? That's why you need very clear structure around your investigations. And Sharon, you're the investigator, so you jump in on this one.
Well, it's really funny because I do focus a lot from the investigator standpoint. And when you talked about who's doing it, I had an investigator who had gone through my training called me because she was with a new organization of investigators. And but she was a manager came and they were talking about a complaint that had been made. And she said, well, the person that was filing the complaint, it was like, well, please don't let it be a white male because, she knew in her mind, she was thinking it was a white male. He didn't have a claim or anything. And so she called me about it because she says, I know that's not what we learned in class. And I said, no, it's not. It protects everyone. Now, some of the confusion also, I think we got to go back historically a little bit. We know that when the Civil Rights Act was passed, it wasn't because of white males being discriminated against.
Right.
It was because of what we were seeing in our TV screens. It was because of the abuse of what we saw happening with Black Americans during that time. So the reality of it is that when that law was passed, that act was passed, it wasn't because white males were being discriminated in the workplace. Let's be real. Okay. But as we fast forward and we look at the balance, equal opportunity, it never said equity, it said equal. But I think because of what we know was happening, because of some of the egregious discrimination that was happening in the workplace prior to 64, we knew that it was so far behind. How do you catch up? I mean, just in 63, you could write ads saying, oh, I want a white female, I want I mean, you could specifically say that. Now, today, that sounds ridiculous, right? But that was, you could do that. You wanted someone and you could actually say that. So now that sounds ridiculous. And even after the Civil Rights Act, there were still employment agencies where employers were going in and saying, I want a white female for this young white female. And they had codes. There are cases you can go on EEOC site and see where cases were filed, where even the employment agency. So those things were happening. And that was a reality when you started. And even Johnson, when he spoke at Howard University, I think it was in 1965, he talked about how you don't take a person at the start line and where they've had nothing in the past and say, now you're equal to compete. That's just not reality. So I think that's a big part of what was happening. I use the analogy of the track field. I mean, if we all watch track, have ever been to a track field, when you're doing the relays, if you start everybody on the start line from the center to the end, you can look at that and know doggone well the person on the end got a lot further to trot than the person right in the center. So it's just kind of a sense that you look at, and it doesn't take, a lot for somebody to finally realize that. I mean, a child know what's fair and what's not, in that sense. So that's a big part, I think, of what's happening now that we fast forward. It started to look like, for some, that white males were being left behind. It started to look like, and in some cases, there have been discrimination cases. I mean, Nancy mentioned that. We've seen some egregious ones, and I think part of it too might be that we've got people in DEI that have not had the training, have not had the background. And I've seen some cases where, I mean, I think University of South Florida was doing a certificate. You could get that and all of a sudden, oh, I got a certificate. It was free. And people really didn't have the depth. So I appreciate what you're doing, Nance, and all of that and moving that forward. But that was just my 2 cents on the regulation and where it came from and being real.
Yeah, and thank you for that, because I think it does help with some of the background. So I think we did hit on all of what was on that slide, Chris, is that, yeah, the regulations, the laws are the same. There have been some nuance. You may be in a state where there's a DEI ban, but again, that's addressing how you train your employees, not what you train them on, right? It's the law is still what they have to be focused on, and no discrimination in the workplace based on any of those categories.
So this is, I have an example here, and this is unintended consequences. And this isn't about Ames. This is about In 2023, this is the Supreme Court ruled in Students for Fair Admission versus Harvard, and then SFFA versus University of North Carolina. So both of those got away or did away with race-based affirmation action policies. So you could no longer give preference to, somebody who was one of the protected groups. However, so this is, and they've been following that ruling since then. However, in late 2020, and this is in addition, in late 2025, both Northwestern and Brown University entered into separate settlements with the US government to resolve investigations into anti-Semitism, DEI policies, and to restore frozen federal research funding. So the unintended result of that is that previously many, especially the Ivy Leagues, had a 50-50 male-female quota for their admissions. They wanted to have, roughly equal men and women. Well, what happened is, or what has been happening is that women have been outpacing the men in terms of both their applications, how many are applying, and their scores. So So what has happened, for example, Brown University, they used to accept 7% of their male applicants. So it's very rigorous, but they accepted only 4.4% of their female applicants. Middlebury College had 12.12 for male versus 9.6 for female. So if you no longer have that 50-50 rule, women are now being accepted at a higher rate because they apply in larger numbers and their scores tend to be higher. So unintended consequences. That is that. That's not Ames, that's the other thing. But I thought it kind of fit here with reverse discrimination.
And they argue all the time, right? People argue all the time is we should let the market determine the outcome, right? And that's one of those classic examples of the market starts to determine the outcome, and you might not like the outcome, right? So we're going to continue to see the confusion around it, and we're going to continue to see adjustments made at different stages. So that's the other thing that we often will try to reinforce here, is that it's better for you to have preparation for resolving the conflicts that arise rather than pretending that you're going to be able to avoid them. The changes are going to continue to occur, and at a very fast pace. So strap in. Here we go. So you've already heard us say there's no such thing as reverse discrimination. You're right that they do use that term in certain places, but it's not really a thing. So I like to think of that as a canceled term.
Thank you. And Sharon, your EEO perspective on reverse discrimination, if you have anything more to add. You did have a couple of points here.
I only, we've talked about the reverse, but, from the investigator standpoint, looking at the consistency when you're doing that investigation, are the same rules, same proof, same process when you're actually doing that, making sure that you're consistent across the board, make sure that the comparatives, that's one of the things that oftentimes kind of get put a little bit to the side, but the comparators are very important. And that's the same thing applying to anyone, whether white male, whether, anyone. It's who are the comparators that you're looking at. And then basically the risk trigger, identify, the base decisions, the shortcuts. One of the things, when you talk about the language, in fact, it was really funny. I have a connection with some over in London who sent me some information about things that are being said with their parliament. And there was a woman that had made the comment, we got too many Asians, we got too many Blacks. And so that was a public statement. And so as we've seen some red flags and some things going on in our country, this person was sending it to me kind of saying, hey, we got some things going on over here. But those kind of comments, could mean, when you start looking at DEI, I mean, those can be very discriminatory, but similar to what you were saying, Chris, when you said they were trying, with the story you just told about the universities, they were trying to make a balance. But now what's happening is that protected bases, if someone comes and says, well, we've done that, we've got too many. This conversation is getting, like I said, is rising to a level that we got to be ready to address in the investigation.
So activate, what are we going to do? And this section, as I mentioned, we have with Spectre, we have the data that we collect, but we also have open-ended questions, and they're the client's questions. They can ask whatever they want. And some people say, nope, it's all good. Some people don't answer because it's not a requirement. Some people say, okay, here are the 5 things you need to change. Number 1, number 2, number 3, and they give you a list of here's what needs to happen. And other people tell little stories. And so today we've got some little stories that I'm going to share with you, and then Nancy and Sharon will react to them. So the first one, and this is a direct quote. I believe, anonymous, of course, I believe qualified people who don't fit the diversity profile will be left out. For example, an African-American male with several degrees and experience in the field is not hired because a gay African-American male with the same degree and experience is needed to meet a diversity standard. That is discrimination and unfair. Exclusion happens when we overly stress inclusion, and some of the brightest minds are left out because they don't fit a profile. And I'd like to know what the diversity profile is.
Well, and I think one of the answers to your question is it depends, right? Classic lawyer answer. And it depends on the organization. And I have worked on cases where there have been specific hiring committees put together that said, we're not going to hire this type of person. And they threw all of those candidates in the trash. And that was discrimination. Just prima facie discrimination. So it does happen. And what you're asking is there one diversity profile? And the answer is no. It depends on the organization and what they're trying to achieve. And what now we're looking at in more advanced stages, we'll say more mature stages of DEI and whatever we're going to call it in the future. I mean, all of us have been in this work since before it had the label DEI. So changing the label for us, I don't think is really going to change our mission. And that's what we're trying to get across to the organizations as well, is it's not about the looking good, it's about the doing good.
And Sharon, do you have?
I absolutely agree with what you're saying, Nance. People that have been in my training, people that have been around me for years have heard me say that I felt the label would get us in trouble. Because again, once you have a label, it makes it very easy to attack and very easy to pull off the shelf. And so it's doing the work. And doing the work is what DEI is all about. I mean, it was never about bringing someone on that wasn't qualified. It was about opening the field so that you could see who all these qualified people were out there, so that when you're making your selection, you pull them in. I mean, regardless of what your race, gender, or whatever, if you're a woman, you don't want to work with a woman that's hired who's totally unqualified and not there to support what the organizational goals are. So it's never been that way. And I'm just, we don't know how this, once we're out of the mix, we don't know how it's going to come about, but I'm hoping that there's an opportunity to really look at it and maybe bring, as you mentioned, advanced or better with DEI, because for those of us that've been around in a long time, we've seen the evolution of it. We've seen the scary things that have happened when people are doing DEI. We've seen that. But we know
what they call DEI.
What they call
right.
DEI. Right. Absolutely. Right. What they call DEI.
That's not the same, right? They're
not the same.
Right, exactly.
There's a great deal of depth to this, but if you don't know as a client the difference, I mean, because as recent as I'll say 3 weeks ago, 3 months ago, 3 years ago, someone was telling me they brought in a DEI person that was separating them by race, that was separating them by gender, that was going through some very traumatic things, and it left the group feeling. And I'm like, they did do that years and years and years ago when it first started, but they learned very quickly that was not a route to go. And so there were people still doing that, So again, I think it's because the skills there, but that's where we're headed. We're hoping, at least till I say, I'm hoping that through all of this, when it's all out of the wash and we're all kind of figuring this out, it will bring something better.
So this this example is about heritage, or the culture of individuals and groups. So, quote, we had an Asian or Pacific Islander identifying provider do a training on cultural sensitivity, and later posing for pictures wearing sombreros, holding tacos, donkeys, and fake mustaches. As a Chicana, it was disgusting to see my people and community represented in such racial stereotypes. The organization continues to pick presenters that perpetuate harm. Why would that presenter have been okay with Chinese cookies, chopsticks, or dragons being representative of her community? Then why was it acceptable to represent Mexican this way, especially in this climate where we are under attack and fear for our safety? And this is this gets to a lot of surveys, and ours included. We include Hispanic under the race section, even though it's an ethnicity and not a race, because the data coming from a lot of different sources, they put Hispanic in with race, and so to make our data coalesce with other data sets, we have done the same, but we recognize that ethnicity is not the same as race. But here's apparently an Asian person, maybe on Cinco de Mayo, wearing sombreros, holding tacos. Where does this fit in? It sounds like it, well, besides being unsensitive, was it legal?
I'm going to give the classic lawyer answer, right? And I have to give my disclaimer too. Although I'm a lawyer, I'm not the lawyer for anybody on here. I'm not giving legal advice, but I would say it's insensitive and it definitely has the opportunity to create a hostile work environment. Now, the incident on its own could be deemed de minimis and insensitive. So de minimis meaning minimal, right? Didn't cause a lot of harm. But we don't know, based on what you were told, we don't know what the whole circumstances were, right? There may have been more that happened in that particular instance. Somebody might have said something, they might have used a slur. There could have been a whole host of things that went with that. And that's what we usually see, is that as we do the investigation, right, Sharon, we start doing the investigation, and when you find out that there's usually a pattern of this kind of behavior. So I think the first thing that I would recommend, of course, to the employer is that you are sensitive to these kinds of things, because there's a tendency to try to do something to be relatable. And that's where a lot of the performative DEI came from, right? Having these different Hispanic Heritage Month or whatever they wanted to celebrate. And we have all those affinity months, those special weeks, months, dates, right? And they vary, and it's hard to keep up with them. And people try to do it because they think, oh, what a fun way to bring people together. But then something like this happens, and you don't know the sensitivities of the people in your workplace, which is also part of the problem.
It could be triggering.
It can be triggering for various reasons. But again, it comes back to, if you know your workplace, you know the people that work for you, you should probably see that coming. And that's why I said it usually points to more. One instance is usually just the symptom of a much bigger problem. It's the first little cut that you find out there are a thousand other paper cuts under there that are causing the place to bleed out.
Like the
Right?
iceberg. A lot
Yep,
of it is
exactly.
underneath. Sharon.
Well, when you're talking about harassment, I agree with what you're talking about, Nancy, when you say the hostile, it could create a hostile environment. And, the first thing, when you're looking at investigating harassment, hostile work environment, that it was unwelcome. Okay. So with the mere fact that they've complained or whatever, it's unwelcome. But there's two words in there, severe and pervasive, that can be so subjective. In terms of what that means. And the more severe it is, the less frequent it has to be, the less fear, then it can be the more subtle things. It's like that drip, the that's kind of constantly coming in, is the microaggressions kind of thing. So yeah, it does depend. And sometimes, it may not prevail to the level of what's considered hostile work environment or harassment based on what a reasonable person would see. And I've seen cases where it doesn't look that way. But again, you have to look at it in terms of, as I mentioned to investigators, it's the story of the person in front of you. It's not your story. It's the story of the person that in front of you. And you have to get the evidence to show why it is that severe and pervasive to them. And when they share those things, it might be something that'll fall out and say, oh, okay, maybe we can see that now.
Dance.
And really important that I just want to throw in there that Sharon is talking from the EEOC perspective, which is the federal law. Please note that your state might have a different standard and might not apply the severe and pervasive standard.
Mhm.
So you have to know these things as well. And
Right.
sometimes localities, such as cities in the larger metropolitan areas, may have their own laws about that. So you're going to need to make sure
Right.
that you know. Now, I, on the other hand, will just say generally it's probably easier to have one rule, right? Which is just don't be a knucklehead, right? Learn about your workplace, learn about the people in it, understand the cultures that they may identify with, get to know your people, find out before you bring in something like that, and offer some sort of performative DEI. Make sure that you're thinking it through of who could be offended. Would I be offended if this were my culture being represented, right? That's the kind of thing, but also recognize that you and your view, as Sharon pointed to, it's not about you, it's about the people that work for you.
Third example, once again, quoting, quote, if the organization is conceptualizing diversity as race and gender, then they're doing great. I feel there's a lot of diversity trainings that are offered for free. I love the one that was offered for free in Spanish recently. However, if we're looking at other diversity factors, then things are not going well. There is absolutely an unofficial hierarchy of political power that seems to get special privileges. The most disappointing fact is that this feedback only seems to have fallen on deaf ears. Not only has it fallen on deaf ears, but has been met with defensiveness that makes me feel unsafe in providing it outside of an anonymous survey. If you want to find examples, just look through the Facebook groups. And I'm assuming they're, end quote, I'm assuming they mean their company Facebook groups, not Facebook like in general, but favoritism, cliques, little groups. What would you like to say about that?
So many things. I'll start with just that hierarchy, and it brings us back to something in that first fact pattern as well, of this perception that there is a hierarchy, that there's somehow like points, like there's some sort of point system of, oh, you're female and you're over 40 and you have a disability. Oh, and your religion might not be Christian, right? And so it's like there's like, oh, like giving you points for it, right? That's not how we work, right? That's like that doesn't work. It may mean that you have more than one claim to address, because it may be that they've experienced discrimination based on multiple categories, but it still isn't a scoring system. It still comes down to, is it discrimination or not? And that's back to Ames. But the other thing that you also brought up in that was completely slipped my mind. I'm just completely losing my train of thought. But it's
Special
about this type.
privileges,
Excuse me?
special privileges,
The
maybe.
special privileges, and it's the way that we're processing the information. And I think, Sharon, you've already hit on this as well, that there is no special treatment that you should be giving to anyone. And the clicks, you'll see it. You'll see it, start to see this happen in organizations where maybe it's all the younger people gravitate together, all the older people gravitate together. And look, they're there to work. And I hate to sound harsh in that, because you want them to get along and it's fine if they hang out outside of work, etc. But when they're there in the workplace, they're there for the joint purpose of pursuing the work. And it's a bonus if they also can have a friendship, but that's a friendship outside of work. If the work's not getting done or there's discrimination occurring, they're not doing their job.
Yep. Sharon.
I think you said that well, and you're there to get the job done, but sometimes I think when people start to see clicks, what it does is it start to say, I can't get ahead because I don't fit that. So that starts to affect the perception that you talked about. And I'm just going to say this case very quickly. I remember this case many, many years ago, because people often ask me, can the same race, same gender, whatever, can they file a complaint against each other? And I'm like, well, yeah, they can, but you still got to follow the same process, in terms of looking at why they're saying that, what the comparators were. And there was a Black male that filed a complaint against his Black female supervisor because he felt that there was more women working in there and he would never have an opportunity to move forward because they were only looking out for women. And then he also felt she discriminated against him, not only his gender, but his race, because he dated a white woman and he felt like she didn't like him. She discriminated against him because he did that. So here's a really one of those complex cases you see, but look at all the dynamics of what's going on in there with the same people. So again, going back to, you can see the law protects everybody.
The other thing that, we handled this in one of our annual reports, but and you kind of alluded to it, the intersectionality. We're not just one thing. Like if there's a banquet and that says, CEOs over here and parents over here, and former mountain climbers over here,
Where do I sit?
which table would I sit at? It's like, no, we're all many things. And
And I think that's the key piece of Ames that I want to emphasize at this moment, is that it's the perception of being in a particular class, the perception of having more or less power. It doesn't mean that your perception isn't supported by evidence, but that is again the purpose of the investigation.
okay, moving along to lead and inclusive leadership tips. Got a few. And we've kind of talked about this. DEI isn't about optics anymore. It's about how leaders use their power every day. And yeah, that's all I'll say about that. Inclusive leadership drives better thinking, and there are so many studies that show how being inclusive is a good thing. And keep in mind that, and I know next month we're going to have two guests with us for our next topic, and they will, I'm sure, emphasize this point that inclusion is the leading indicator. You do inclusion first, and then diversity is the result. You don't do it the other way around. So diversity is a following indicator. And third tip, when belonging is real, people stop playing safe and start doing their best work. End of story. Nancy, legal.
I would like to say that takes a little more than that. You still have to, as a leader, just to make sure you're also training people and supporting them. But that's really what we're talking about with inclusion as well, is that you need to give your employees the support they need, which might mean an accommodation for religion or disability. But going into the inclusive leadership, you want to make sure that whatever you're calling your policies at this point, right, is that you're looking at them for any language that excludes or favors anyone based on a protective class. You should know that by now. Your legal department should have been on top of you about that. Um, but it's pretty simple, and where we see it still showing up, I think, more than ever, is with those employee resource groups in larger organizations, that they may have said, this is for women only. It's like, look, you can focus on women's issues without excluding men, and if anything, it's better when you have men come in and hear the stories of women in the workplace and share and work on these issues together, because at the end of the day, you're still going to have to work together. There are very few organizations where you're not going to have to work, men and women and people that don't identify as either, working together in the same workplace.
Ensure your EEO investigators are properly trained recently.
And I'm going to let Sharon take that one, because I know she does the training, and
Oh,
we
well,
know that a lot of confusion is going to continue to occur.
yeah, there probably is. What we recently saw, I mean, to see an investigator's name put out there is very unusual. The circumstances that I've seen it happen is when they are criticizing the investigation. So being trained is extremely important. There was a case back in 2020, I think it was King versus US Bank, but where the investigator chose not to interview the respondent, interviewed everyone else, said she had enough information, knew what it was, and moved forward. But anyone with training would know that you don't do that. So that training is extremely important. And sometimes because of that situation, it may be grounds to just literally, throw a case out in support, of the person filing the complaint. So it's real important, for investigators, I always put emphasis on this, is to be trained and understand there's some basic things you got to know. And I think that's going to be even more relevant as we move forward in doing that. Yes, Nan.
Yeah, and I was just going to throw in there that not only are we talking about doing a training in a single setting, or however long you might do it, if you do an online self-paced one, we're not just talking about that. You also want to make sure that your investigators are trained on the actual investigations, right? So I like to think about, you deliver the knowledge, then you apply the knowledge by maybe partnering, being the second chair on an investigation, working with an investigator, so that you have the experienced investigator saying, oh yeah, we see this come up and here's how we handle it. You may think, right? You think and I've done the investigations too, and I still will sometimes phone a friend, right? Because you're always going to get some that's a little out of the ordinary. And if you're just on your own trying to do it that way, you're very likely to make a mistake, because these are very subjective types of situations, meaning that they're based on the people, the organizations, and the individual facts and circumstances.
Audit your prior investigations for biases.
So
Who
then
says
obviously you want to, I brought that one up, and because in organizations that are concerned at this point that maybe they have had some discriminatory policies, or they've been inviting some problems, maybe that's why we do this too, is to give you an opportunity to go, oh, maybe we haven't been doing these well and we might get caught. Well, this is a good time to get that wake up call, to go back and look at your prior investigations for the biases, as not necessarily be as the name and shame and blame, but looking to see, have you a pattern in your organization that's setting you up for failure in the future. Now, obviously, if you discover something during that investigation, you would want to flag legal counsel to find out, is this still within the statute of limitations? Should we be taking legal action? But also looking at the ones that are beyond the statute of limitations can be very telling for your organization, just like doing the assessment, right? Doing an assessment for biases. All of that can be valuable information if you're really committed to laying a solid foundation for your organization to be sustainable long into the future.
And I think this one is yours, Sharon.
Yeah, I think that's
Standardized.
probably you,
Yeah.
Sharon, but
I was one of the things you talked about was, in terms of the investigation. And one of the things I say to investigators, you have to be a continuous learner. You can take a training. That's great. You can get a certification. That's great. It may get you in the door, but it will not keep you there if you don't know this stuff, because you can really go awry in putting things in there that shouldn't be, as we've seen with some investigators out there. So I think that that's extremely important as we move forward as an investigator, is to stay on top of those things and the decisions. I laugh when I talk to investigators or people that's been in this industry for years. I've been around a long time. I have to cover my mouth when I say, but I'm going to say up on 30 years. And when I go back, I can tell you we laugh about it. For those that have been around this long, as we say we are ancient, we kind of chuckle about it, because you go back and look at some of the stuff and you go, whoa, did that get through? Because what was happening is back then, none of us knew a lot of the stuff that was going. We were all trying to figure it out. I can tell you theories and prima facies have been around forever. However, there's other things where decisions have been made since that time that you go back and look at it and you go, oh, wow, that shouldn't have gotten through. But they did. They got through because we were all trying to figure it out. But now I think it's a lot more sophisticated, not only in terms of the sophistication for investigators, but also for the complainants and the respondents. I mean, they're more knowledgeable now. I mean, when I first started, you get one complaint, say race, gender, and that was it. Oh, you're not getting that anymore. It's going to come in with the kitchen sink, as we refer to it. And some of it's just thrown in there because let me see if it sticks. Some of it gets through that shouldn't get through. But again, I think I just want to reiterate, that part about being a continuous learner, because this is an industry in which you have to, and particularly now.
And this was, I didn't add this one. This was Nancy's.
it just comes up naturally in this, that really, if you want to know what's going on in your organization, you have to do these anonymous assessments. You have to do your you have to have conversations with your employees. You have to do your due diligence from a variety of angles. And I think it's, to your point, Sharon, this also plays in with, generally, you have to be a lifelong learner if you're going to be in any industry at this point. Everything's going to continue to change. And I know that's not what most people want to hear, but there is no point in your career where you're just going to put your feet up and slide on into retirement. And that's just not the way it works.
Not going to happen. No. So that concludes this session.